actually do have an update for you. I've been sitting on that update for 13 days, but I never recorded the video because I was waiting on the judge to issue a ruling. You see, at the end of that hearing, which I did attend in person and took notes for, he did not issue a bench ruling, meaning he did not rule in that moment. He took the matter under advisement with good reason. It was a very technical, technical is the best word. Technical hearing, meaning that there are service and procedural issues which do impact the ability to proceed in the case if the defense wins this motion, i.e. Emani Green, the defendant, the main defendant who was seen on video fighting with Shanquella and allegedly assaulting her, that assault which resulted in her death, could be dismissed from this case. I'm going to break it down to the best of my ability. Certified law nerd, bona fide non-attorney. This is not legal advice. My interpretation of what I heard in the court hearing that day. Let's begin. Let me set the scene in the courtroom. I was physically present for this hearing, and to my knowledge, I do not believe any media was present. On the plaintiff's side, I saw Shanquella Robinson's mother and father. It also appeared that other family members and associates were present. There was someone typing on a laptop toward the back, but they were seated on the plaintiff's side and appeared to engage with plaintiff's counsel, so I'm not sure whether they were media or connected to the plaintiff's team. On the defense side, it appeared to be mostly, if not entirely, attorneys. Emani Green herself was not present, which is not surprising given that one of the issues in this hearing is whether she resides in North Carolina or Connecticut. Also, a side note, the Mecklenburg County Courthouse is a very nice courthouse, especially compared to Durham County Courthouse. Sorry, Durham. I'm not trying to offend anybody, but it really is much nicer. Bigger courtroom, cleaner setup, very official. The judge was articulate, engaged, asked a lot of questions, and listened closely to both sides. He did grant media requests, but he clearly runs a strict courtroom because he ended up kicking somebody out and banning them from ever returning because they were recording on their phone. Now, this hearing was not about the facts of what happened to Shanquella in Mexico. The court was not deciding whether the allegations in the complaint are true. We are not there yet. This hearing was specifically about service of process. The service of process is a required legal step that brings a defendant into a lawsuit in the first place. Before a court can move forward against someone, that person has to be properly served. And Green's side is arguing that she was not. Her defense is making three main arguments. First, they argue that service was improper because the lawsuit papers were served at a Jamestown, North Carolina address by leaving them with a relative. Green's side says she had not lived at that address since April of 2021, that she moved to Connecticut in December of 2022, about 2 months after Shanquella's passing, and that this relative was not authorized to accept service for her. So their position is, if that was not Green's dwelling or usual place of abode, then service was not valid. And if service was not valid, this North Carolina court does not have personal jurisdiction over her. Second, they argue that service was untimely. This case was initially filed in state court in late October of 2024. Then it was removed to federal court on November 14th of 2024 because claims had also been brought against federal defendants, including the FBI and the Department of Justice. Green's side says that the federal rules controlled the service issue. Under Federal Rule 4M, a defendant generally has to be served within 90 days. Their argument is that once the case was removed to federal court, the plaintiff had 90 days to serve her, and that deadline would have been February 12, 2025. But according to Green's side, service was not allegedly completed until May 7th of 2025. So their argument is, even if the court thinks the May 7th service counted, it was still too late. Third, they argue that if service was improper and untimely, the plaintiff cannot simply fix that now through a retroactive extension, meaning going back and giving them an extension to go back and fix the issue, because the statute of limitations has become an issue. Essentially, their position is, you served the wrong address, you served too late, and now it is too late to cure the problem. Therefore, the court should dismiss the case against Green. Now, the plaintiff's response is very different. The plaintiff is saying, no, this was not neglect. They were not just sitting around doing nothing. Their argument is that Green was evading service, that she was difficult to locate, that they investigated both North Carolina and Connecticut, including hiring a private investigator, and that public records still connected her to North Carolina, including North Carolina registration, North Carolina license plate, North Carolina license. They also argue that when service happened at the Jamestown address in May, the relative accepted the papers, confirmed that this was an address for Green, and that Green ultimately received the documents. But the biggest issue, at least from what I heard in the courtroom, was Green's own federal court paperwork. After the alleged service on May 7, 2025, Green filed documents in federal court. At the time, she was pro se. In those documents, she acknowledged being served, and she used that same Jamestown, North Carolina address as a mailing address, and the judge specifically called that out and said that it was nonsensical. His point was, how can the defendant argue that this address was not acceptable for service, but then cite that same address as an acceptable mailing address in documents she filed with the federal court? That seemed to be the major hole in the defense's factual argument on service. But that did not fully end the issue, because the harder question became whether the state court even has the authority to fix or extend a federal service deadline after the case has already been remanded back from federal court. Remember, this case started in state court. Then it was removed to federal court because there were federal defendants involved. Those claims were dismissed, and after that, the case was sent back down to state court. So now the parties are in state court arguing about a service issue that happened during the federal court phase under a federal summons. Technical. Super technical. The judge said he had reviewed case law cited by the defense and that the case law did appear to support the argument that a state court may not have jurisdiction or authority to grant a retroactive extension for a federal summons. That is a real problem for the plaintiff, because even if the judge is skeptical of Green's argument about the address, he still has to determine whether he legally has the power to give the plaintiff more time after the fact. And that is why he took the matter under advisement and did not issue a ruling in that moment. So the big takeaway is this. The judge did not seem persuaded by the idea that the Jamestown address was completely unacceptable, especially because Green herself used that same address in the federal court filings. But the judge did seem concerned about whether the state court has the authority to retroactively extend the service deadline when the summons at issue came from federal court. And the plaintiff asked, well, can we take this up to federal court? And the judge said, no, this is gone from them. This is remanded back to us. This is something we may have to solve for and unfortunately rule with what we've got. And ultimately that matters because his ruling could determine whether Emani Green stays in this lawsuit. So what happens next? It is really hard to say. We really need this judge's ruling. We don't understand the scope of authority and jurisdiction that this court has yet because of all the issues that were raised by the defense. And so first off, we need to know whether he rules in favor of the defense or the plaintiff. If he rules in favor of the plaintiff, we're going to proceed and they might be able to correct some of these issues retroactively, although it did sound in the hearing like this court does not have the authority to do so. I think this is why it's taking so long for the judge to rule. However, if they rule in favor of the defense, it is possible that they may need to restart the process, and it doesn't necessarily mean that Emani Green is off of the case or out of the lawsuit altogether, right? Right, I think. I have to wait. This one's actually going to be very mentally stimulating for me because there are so many technical, procedural, and statutory issues that they have to deal with. This case started in state court, was sent off to federal court when the FBI and Department of Justice were named in the complaint, and then sent back down to state court. And so there was a lot of changes in jurisdiction. It's just a lot of hoopla. If you're still with me, great. This shit's complicated. So just stay with me. Let's figure this out. The next hearing is in July. This was filed on behalf of counsel for Khalil Cook. They are also asking for a motion to stay, and they are citing jurisdictional issues. They are arguing that this took place in Mexico, so it should not be in North Carolina. I will keep an eye on the docket and keep you updated. Catch you in the next one.